Ever wondered what happened to the road rage case of Jason Ivler, which resulted in the manhunt, then an arrest shootout? Did you know that he was charged with 2 criminal complaints? First, reckless imprudence resulting to slight physical injuries. Second, reckless imprudence resulting to homicide and damage to property, but was only convicted with the first charges, slight physical injuries, and was acquitted in homicide because of double jeopardy. Disclaimer: our videos on laws are based on actual cases. The facts stated have been made public through publications and the internet. If any details, especially of the plaintiff and defendant or accused, offensive in any way, kindly leave a comment or message us in our Facebook, and we will be more than happy to change any details accordingly. In the Ivler versus Honorable Modesto San Pedro case, double jeopardy was evoked by the accused and Article 365 defined as a single crime. Facts: following a vehicular collision in August 2004, petitioner Jason Ivler, petitioner, was charged before the Metropolitan Trial Court of Pasig City Branch 71 METC with 2 separate offenses. 1. Reckless imprudence resulting in slight physical injuries. Criminal case number 82367 for injuries sustained by respondent Evangeline L. Ponce, respondent Ponce. And 2. Reckless imprudence resulting in homicide and damage to property. Criminal case number 82366 for the death of respondent Ponce's husband, Nestor C. Ponce, and damage to the spouse's Ponce's vehicle. Petitioner posted bail for his temporary release in both cases. On September 7, 2004, petitioner pleaded guilty to the charge in criminal case number 82367, meted out the penalty of public censure. Invoking this conviction, petitioner moved to squash the information in criminal case 82366 for placing him in jeopardy of second punishment for the same offense of reckless imprudence. The METC refused quashal, finding no identity of offenses in the 2 cases. After unsuccessfully seeking reconsideration in an order dated February 2, 2006, the RTC dismissed the SCA number 2803, narrowly grounding its ruling on petitioner's forfeiture on standing to maintain the SCA number 2803 arising from the METC's order to arrest petitioner for his non-appearance at the arraignment in criminal case number 82366. Thus, without reaching the merits of SCA number 2803, the RTC effectively affirmed the METC. The petitioner sought reconsideration, but this proved unavailing. Issue: whether petitioner forfeited his standing to seek relief in SCA 2803 when the METC ordered his arrest following his non-appearance at the arraignment in the criminal case number 82362. If the negative petitioner's constitutional right under the double jeopardy clause bars further proceeding in criminal case number 82366. Decision: wherefore we grant the petition, we reverse the orders dated the 2nd of February 2006 and the 2nd of May 2006 of the Regional Trial Court of Pasig City, Branch 157. We dismiss the information in the criminal case number 82366 against petitioner Jason Ivler E. Aguilar, pending with the Metropolitan Trial Court of Pasig City, Branch 71 on the ground of double jeopardy. We hold that one petitioner's non-appearance at the arraignment in criminal case number 82366 did not devise him of personality to maintain the petition in SCA 2803, and second, the protection afforded by the Constitution shielding petitioner from prosecutions, placing him in jeopardy of second punishment for the same offense bars furthering proceedings in criminal case number 82366. The accused's negative constitutional right not to be twice put in jeopardy of punishment for the same offense protects him from, among others, post-conviction prosecution for the same offense with the prior verdict rendered by the court of competent jurisdiction upon avowed information. It is not disputed that petitioner's conviction in criminal case number 82367 was rendered by a court of competent jurisdiction upon a valid charge. Thus, the case turns on the question whether criminal case number 82366 and criminal case number 82367 involve the same offense. Petitioner adopts the affirmative view, submitting that the two cases concern the same offense of reckless imprudence. Reckless imprudence is a single crime. Its consequences on persons and properties are all material only to determine the penalty. The two charges against petitioner arising from the same fact were prosecuted under the same provisions of the revised penal code as amended, namely Article 365, defining and penalizing quasi-offenses. Reckless imprudence consists in voluntary but without malice doing or failing to do an act from which material damage results by reason of an excusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate nor the danger clearly manifested. Reason and precedent both coincide in that once convicted or acquitted of a specific act of reckless imprudence, the accused may not be prosecuted again for the same act. The next question is to determine the relation between the first offensive violation of the motor vehicle law prosecuted before the Pasay City Municipal Court and the offense of damage to property through reckless imprudence charged in the Rizal Court of the first instance. One of the tests of double jeopardy is whether or not the second offense charge necessarily includes or is necessarily included in the offense charged in the formal complaint of information Rule 113, Section 9. Another test is whether the evidence proves that one would prove that the other, is to say whether the facts alleged in the first charge, if proven, would have been sufficient to support the second charge and vice versa, or whether one crime is an ingredient of another. Hence, we hold the prosecutions under Article 365 should proceed from a single charge regardless of the number or severity of the consequence. In imposing penalties, the judge will do no more than apply the penalties under Article 365 for each consequence alleged and proven. In short, there shall be no splitting of charges under Article 365, and only one information shall be filed in the same first-level court. Our ruling today secures for the accused facing an Article 365 charge a stronger and simpler protection of their constitutional right under the double jeopardy clause. True, they are thereby denied the beneficent effect of the favorable sentencing formula under Article 4.8, but any disadvantage thus caused is more than compensated by the certainty of non-prosecution for quasi-crime, effect qualifying as light offenses. Please note, as of December 2019, accused Jason Ivler was convicted for murder in the case of People v. Jason Ivler, GR number 241783.